Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. We have arrived at the last podcast episode of 2024. Can you believe it? Believe it. Because I'm feeling the holiday cheer throughout my bones, and because I respect Michelle and the National Immigration Project very much, I wanted to give mega pod congratulations to the NIP attorneys Michelle Mendez and Victoria Nielsen for writing Trial Skills for Immigration Court, a practical guide to effective strategies and tactics. The book is published by Ayla, and it's Ayla's first book that discusses how to litigate cases in immigration court. Seems like an overdue necessary resource if you ask me, all the more so given what many of us think is coming in the next 4 years. The book is intended to give immigration attorneys and qualified representatives solid grounding in legal issues like rules of evidence, while being chock full of practical tips and examples of how to effectively prepare questions for your immigration court hearings and what pitfalls to avoid. Whether you're a beginner or an old pro, Michelle writes, you'll find a lot of helpful information in the book. Congratulations, guys. Link to the book on Ayla's website and in the show notes. And you know what? While we're with Michelle and the NIP, Michelle and I wanted to make everyone aware of the nationwide class action settlement in JOP v. DHS out of the District of Maryland. That lawsuit challenged a 2019 policy that limited the ability to seek asylum for certain children who arrived in the country alone. The National Immigration Project, along with Kids in Need of Defense Kind, Public Counsel, Bet Tezek Legal Services, and Goodwin Proctor, represented the certified class and the named plaintiffs, who came to the United States as unaccompanied children and whose asylum applications would have been rejected by the USCIS under the challenged 2019 policy. The court certified a nationwide class and entered an expanded preliminary injunction in December 2020, and in 2024, granted final approval of a class-wide settlement agreement. I've included a link to 5 key takeaways to know for your clients in the show notes. But heads up, there are deadlines, the ability to file new asylum applications, the ability for termination of removal orders and removal proceedings, and more. Check it out. Happy holidays, everybody. Pull up a glass, or dare I say a carafe, of eggnog. We're in for a long one this week. So let's get to it. Our first case is none other than Singh v. Garland, published by the Ninth Circuit on December 24th, 2024. This case is about India Sikh asylum claims, motions to reopen, and credibility. And it starts like this, quote, "Can lips, which once lied, ever utter truths? In immigration cases, it depends upon who answers that question and upon what was said," end quote. Gonna be a fun one. Mr. Singh is from India, and he is a Sikh. He brought asylum claims in immigration court based on his asserted association with the Simranjit Singh Mann Party, the Mann Party. Although this claim is different from many other Mann Party claims discussed on the podcast. In this case, Mr. Singh claimed that he was once part of the rival, less nationalistic Sikh advocating party, the Badal Party, but that he later joined the Mann Party. And for that he claimed he was beaten by Badal Party members. They're not always Hindu nationalists against Sikhs in these cases. Sometimes it's Sikh versus Sikh. In his border interview, Mr. Singh said that they, the Badal Party members, beat his father too, but that his father wouldn't be coming to the United States, but that the father had decided that Mr. Singh would be. Again, so stated in a border interview in 2013. At his credible fear interview after that, Mr. Singh reiterated the story, but, quote, confirmed he did not suffer persecution on account of his race, religion, nationality, or any particular social group, end quote. Not sure what that means for a pro se individual sitting in a credible fear interview, but there you go. Once it all got started in immigration court, Mr. Singh asserted fears based on an anti-Badal Party political opinion and membership in a particular social group. And in his signed statement accompanying the Form I-589, Mr. Singh, quote, mentioned for the first time that his father had been killed by members of the Badal Party, end quote. In 1994, no less. So that's not looking great. Then, in a more detailed signed statement submitted before his merits hearing, Mr. Singh was apparently vague about when he worked for the Badal Party, and said that he had been in a hospital for 10 days after his beating, treated by a Dr. Gurmeet Singh. The signed statement also said that during the second beating, the Badal Party members told him, Mr. Singh, that they were the ones who killed his father in 1994. Mr. Singh produced a birth certificate showing the 1994 death in immigration court. At a merits hearing, Mr. Singh's counsel was unable to identify a particular social group, so the immigration judge adjudicated the matter as a political opinion claim. Then, Mr. Singh testified that he had never actually been a member of the Mann Party. Then on cross-examination he testified that he'd never been a member of the Badal Party either, although he did interact with them often. And Mr. Singh's years were kind of off too, as compared to his prior statements. It actually goes on for a bit in the decision, all the inconsistencies and problems, and the IJ denied everything based on an adverse credibility finding. It got so bad that Mr. Singh's counsel requested a continuance mid-merits hearing during cross-examination, which an IJ denied. Rough. To be fair, somehow Mr. Singh's hearing was continued, and he then clarified that his father was dead, but his paternal grandfather was alive, and that that's the guy he was referring to at the border interview. The Ninth Circuit calls this testimony in part, quote, preposterous, end quote. Anyway, an IJ denied and the BIA affirmed on adverse credibility. Even the Ninth Circuit then affirmed in an unpublished decision in 2021. But Mr. Singh remained in the United States and also in 2021 moved the BIA to reopen his asylum claim. Now he argued that, quote, a new fear of persecution had arisen as India had passed certain agricultural reform laws in 2020, end quote, known as the Farmers' Laws. This is a law that the Ninth Circuit notes in a footnote is not still in effect due to widespread protests in India, which I seem to recall. Mr. Singh also claimed asylum for the first time based on his Sikh religion. As a primary basis for the claim, Mr. Singh submitted a detailed sworn statement. It discussed how his family were farmers, his grandfather protested the farmers' laws and was beaten by BJP members for it, that is the governing Hindu-based party of India. And medical records were submitted to support that, as were photographs and land ownership papers. Plus, of course, country condition evidence about the farmers' laws. The BIA denied the motion to reopen. It believed that the relevance and the materiality of the evidence relied on Mr. Singh's credibility, and well, he wasn't credible. The maxim falsus in uno, falsus in omnibus, Latin, for false in one, false in all. In the Ninth Circuit, IJs can absolutely rely on this maxim to deny relief, explained the Ninth Circuit. Something I remember vividly because, well, I was an attorney advisor in the Ninth Circuit when that decision came out, Levy Holder. Quote, but that power belongs to IJs, not the BIA, end quote. The Ninth Circuit remanded the BIA's denial of the motion to reopen. Apparently the Ninth Circuit has already pretty much made this ruling in Yang v. Lynch from 2016. Kinda makes sense, right? Only IJs engage in fact-finding, and finding someone not credible, even for a second time, based on new claims and new evidence at least, would seem to require fact-finding. So limited, the BIA, quote, must credit evidence supporting a motion to reopen unless the facts asserted in that evidence are inherently unbelievable, end quote. Now, the BIA can compare new evidence to the evidence previously submitted, and that was deemed not credible in its inherently unbelievable analysis. Plus, there's the Ninth Circuit decision Greenwood v. Garland, episode 112, where the Ninth Circuit itself said that the BIA, quote, may rely on a previous adverse credibility determination to deny a motion to reopen, end quote. Sticky issue, then. How to square that with Yang and the fact-finding thing that I just mentioned? Well, Greenwood missed Yang, the panel notes in a footnote, but more importantly, in Greenwood, the credibility issue remained the same on both the merits and the motion to reopen. Mr. Greenwood's very identity was unclear throughout. Quote, accordingly, Greenwood stood for a common-sense proposition that an earlier unproven fact, not an unreliable witness, remains unproven in a later proceeding unless effectively corroborated by new evidence, end quote. This is different here. In this case, the BIA is saying that Mr. Singh is and will remain an unreliable witness, even if he's asserting different facts. And heck, the Ninth Circuit appears to have pretty much said that or something like it in another Singh v. Garland decision from 2022, episode 123. That is, to succeed on a motion to reopen with a prior adverse credibility finding, a non-citizen, quote, must either overcome the prior determination or show that the new claim is independent of the evidence that was found to be not credible, end quote. By the way, and this is just me, all of this seems a bit in tension with the BIA's 2020 decision matter of FSN. So if you're in the Ninth Circuit and playing this game, make sure you're following the rules of this Ninth Circuit non-citizen-friendly decision and the cases it relies on, and not matter of FSN. The Ninth Circuit summarizes its rule as follows. An item of fact deemed not credible, including testimony, remains not credible, and can be disregarded by the BIA. Quote, likewise, an item of fact unproven at the non-citizen's removal proceedings remains unproven, and the BIA is free to disregard it, unless the non-citizen effectively corroborates it with new evidence submitted in support of his motion to reopen, end quote. But when faced with a motion to reopen for a previously deemed not credible person, the BIA must, quote, discern what facts were tainted by the non-citizen's discredited testimony and were not established by other evidence, end quote. A new affidavit alone asserting the same old facts, but better? The BIA actually can still probably disregard that because the non-citizen was previously deemed not credible. But, quote, if a factual allegation was not presented at all in the non-citizen's removal proceeding, the BIA must accept it as true unless it is inherently unbelievable. The BIA cannot disregard the non-citizen's new factual allegations simply because the non-citizen was previously found not credible as to other different factual allegations, end quote. And that seems like kind of a big deal to me. Returning finally then to Mr. Singh, his motion to reopen has nothing to do with Mann versus Badal Party issues. Now his asserted claim is based on, quote, his religion as a Sikh, his membership in the particular social group of farmers, as well as his political opinions for the Mann Party and against the farmers' laws, end quote. And none of these factual claims were really brought up last time around or deemed not credible yet by an IJ. True. Mr. Singh again asserts membership in the Mann Party, but he included an affidavit from a Mann Party representative about that last time. And while the IJ gave it limited weight last time, the IJ didn't outright reject that affidavit. So it's not all inherently unbelievable, as the Ninth Circuit is putting the standard to reject such things on a motion to reopen. Mr. Singh gets his remand. And so congratulations, Mr. Singh, who apparently represented himself pro se, but also lawyer Jaspreet Singh from New York. He is listed as well, so unsure how he's involved, but congratulations, everybody. The BIA can't just rely on a prior adverse credibility finding to reject new claims on a motion to reopen in the Ninth Circuit. Big deal. A Christmas miracle, published on Christmas Eve and outlined by me on Christmas Eve. To all, a good night. And that is Singh v. Garland. Next is Chmukh v. Garland, published by the Ninth Circuit on December 23, 2024. The Ninth Circuit was not going to go gentle into the good night of 2025. No. 3 big decisions, 2 of which were adverse for non-citizens. We already did the good one. Here are the 2 that were not good for non-citizens. So, as I mentioned, rage against the dying of the light was the vibe coming from the Ninth Circuit this week. This case is about aggravated felonies and particularly serious crimes. Mr. Chmukh is from Ukraine and came to the United States with his family as a refugee in 2001. But he didn't naturalize, as so often tragically occurs in these cases, and likely as a young man got into trouble when in 2017 he and his friends used a stolen vehicle to steal packages from other people's porches. So he's the one. It got him convicted of possession of a stolen vehicle in violation of Revised Code of Washington, Section 9A.56.068. Separately, he also pled guilty to possession of a controlled substance, heroin, in violation of Revised Code of Washington, Section 69.50.4013. So Mr. Chmukh is in trouble. 43 months for the vehicle stuff and 24 months for the drugs, but he ultimately served only 38 months in prison. DHS charged Mr. Chmukh as removable for a few reasons, including that the possession of a stolen vehicle conviction was an aggravated felony, as defined at INA Section 101A43G. An immigration judge agreed, and additionally found Mr. Chmukh removable for the controlled substance violation. The IJ then deemed the vehicle thing an aggravated felony that was a per se particularly serious crime for asylum and withholding of removal purposes, and then denied Convention Against Torture protection on the merits. The BIA affirmed. And here, a split Ninth Circuit panel agreed. Before getting there, though, by the way, I should note that the Supreme Court's Nasrallah decision would permit review of the denial of cat protection even if the conviction is an aggravated felony. But Mr. Chmukh apparently didn't challenge it. So the case becomes solely about whether the conviction is an aggravated felony and a particularly serious crime, such that asylum and withholding of removal are barred. It is, explained to split Ninth Circuit. INA Section 101A43G, of course, describes as an aggravated felony a theft or burglary offense, including receipt of stolen property, for which the term of imprisonment is at least 1 year. The Ninth Circuit saw this as a receipt of stolen property offense. In the Ninth Circuit, such an offense includes the following elements, quote, 1. Receipt, possession, concealment, or retention of property. 2. Knowledge or belief that the property has been stolen. And 3. Intent to deprive the owner of his property, end quote. Seems like the BIA said similarly for the generic federal definition in matter of Dieng, 2017. Now, Washington, in turn, permits conviction for possessing a stolen vehicle if the prosecution shows that the defendant, quote, knowingly received, retained, possessed, concealed, or disposed of stolen property, knowing that it was stolen, and to withhold or appropriate, end quote. And Washington case law explains that those terms are means rather than elements of the crime, meaning a prosecutor need only show one of them, that is, the receive, retain, possess, conceal, or dispose stuff. Seems like a match to me, though, right? Except Washington also criminalizes the disposing of property, while the federal definition appears not to. Doesn't look like that was the first argument, at least, though. To the Ninth Circuit, regardless, the Washington offense requires knowing possession of stolen property. And, quote, since actual knowledge requires an intent to deprive the owner of his property, the state statute also matches the generic offense's intent requirement, end quote. Recall, the federal generic definition requires a pretty high actual specific intent to deprive mens rea, which is where Mr. Chmukh first attacked. After all, juries in Washington are allowed to presume actual knowledge by finding constructive knowledge, and a presumption of knowledge is not specific intent, argued Mr. Chmukh. The Ninth Circuit majority rejected the argument. To it, quote, whether the generic offense considers circumstantial evidence to prove actual knowledge is irrelevant, end quote. Restated, if the element of the federal and state offenses match, as the panel believes they do on mens rea, it doesn't matter under the categorical approach how a state permits those elements be proven. Interesting. And yes, here's Mr. Chmukh coming in with my disposal argument. The Ninth Circuit rejected that because Washington case law makes clear that disposal, like the other terms and the other means in the statute, quote, are so closely related that they do not describe distinct acts apart from actually possessing the stolen vehicle, but are merely facets of the same criminal conduct, end quote. I guess. But isn't that what means are? And I mean, disposing is obviously a different actus reus than, say, concealing. But on the other hand, reason to the Ninth Circuit, no one can ever knowingly dispose of stolen property without first possessing it. Seems like the Washington Supreme Court has rejected such a hypothetical event as well. So the conviction's an aggravated felony. Notwithstanding the ongoing war in Ukraine, that bars Mr. Chmukh from asylum, but not necessarily withholding of removal, unless he has received a term of imprisonment of at least 5 years for the aggravated felony or multiple aggravated felonies. I believe you can't add the imprisonment from the heroin possession thing because that's not an aggravated felony, even though it would get a term of imprisonment of over 5 years, it would seem. Because the Ninth Circuit then went on to decide whether nevertheless, under the BIA's matter of NAM and other similar decisions, the crime satisfies the elements of a particularly serious crime for withholding of removal purposes. That analysis requires consideration of 1, the nature of the conviction, 2, the type of sentence imposed, and 3, whether the circumstances and facts of the conviction justify the presumption that the convicted non-citizen is a danger to the community. Now in the Ninth Circuit, and similar to the Fourth Circuit's ruling earlier this year, quote, the BIA must first analyze the elements of the crime to see if it will potentially bring the offense within the ambit of a particularly serious crime, end quote. If not, it would seem, the particularly serious crime analysis is at an end in the Ninth Circuit at that first prong. But after recognizing that rule, the Ninth Circuit majority really smacked us right across the face. Quote, as an aggravated felony, Mr. Chmukh's conviction for possession of a stolen vehicle is one of the types of crimes most likely to be particularly serious, end quote. No further elements analysis required, it would seem, such as whether the conviction requires harm to a person. If that's what the Ninth Circuit is saying, that is a big deal holding, and to my knowledge has never been the law anywhere else. Having passed that first threshold for the particularly serious crime matter of NAM analysis, matter of NAM kind of opens up the floodgates to permitting consideration of the facts of the offense and really anything else reliable relating to the conviction. The Ninth Circuit saw no error in the BIA's analysis. Now true, if, as Mr. Chmukh argued, the BIA had considered the heroin stuff in its particularly serious crime analysis of the vehicular stolen property, that would probably have been error. But that isn't what the BIA did, said the Ninth Circuit. Nor could Mr. Chmukh argue that he lacked, say, the requisite mens rea, when the elements of his conviction did require that intent. Nor, according to the Ninth Circuit, did the agency fail in explaining why the conviction made Mr. Chmukh a danger to the community, arguably something required by Attorney General Garland's only real substantive precedential decision, matter of BZR, episode 107. The majority doesn't even cite BZR, but there you go. Mr. Chmukh is removable and cannot apply for relief. And so we go to the concurrence and dissent. Judge Van Dyke concurred in full and wrote separately to note that he would make exhaustion of issues quite strict in the Ninth Circuit and overturn the en banc decision of Bebe v. Gonzalez, which is a fairly non-citizen favorable decision on exhaustion, permitting review where the BIA simply summarily affirms an IJ. Here, Judge Van Dyke wouldn't entertain multiple of Mr. Chmukh's specific arguments that Judge Van Dyke believes were not specifically made to the BIA. After all, according to Judge Van Dyke in a pretty incredible statement without citation, quote, everyone knows the usual game in asylum cases is not about making ultimately meritorious claims, it's instead about buying the unlawfully present non-citizen more time, end quote. Judge Van Dyke. Judge Sanchez, for his part, does not appear to agree with that statement, known by everyone, and would hold that the BIA erred in the particularly serious crime analysis for two reasons. First, by failing to analyze the elements of the offense to determine whether they are of the type that makes the crime a particularly serious one. Seems like Judge Sanchez does not agree with the majority's seemingly first-of-its-kind ruling that all aggravated felonies are of the type. And second, Judge Sanchez does cite matter of BZR and would hold that a separate finding of dangerousness is required to make a crime a particularly serious one. Indeed, dangerousness is the, quote, essential key, end quote, to a particularly serious crime finding, as the Ninth Circuit and the Attorney General have explained, states Judge Sanchez. Watch the Ninth Circuit these next 4 years. There already seems to be significant disagreement among judges in the circuits on many issues including immigration, and a few more appointments with Judge Van Dyke's legal philosophy may end up having quite the impact. And that is Chmukh v. Garland. Our final Ninth Circuit case is Magana-Magana v. Garland, published by the Ninth on December 26, 2024. I warned you that the Ninth Circuit decisions are massive this week. This one's about the extraordinary circumstances exception to waive the 1-year motion to reopen deadline under the Violence Against Women Act, or VAWA. Miss Magana-Magana is from Mexico, was born in the late 1950s, and her, quote, life from an early age has been marked by a tragic pattern of abuse and victimization, end quote. No need to go through the whole story, as it's quite tragic. And because the most pertinent part is her last relationship with a U.S. citizen in Arizona named Clyde Wakefield. This after Miss Magana-Magana was granted voluntary departure with her non-U.S. citizen children by an immigration judge and the BIA, but did not depart the United States. That's when she entered this relationship with Mr. Wakefield. And it seems that that relationship, like her others it seems, became abusive. He choked her and seemed ready to kill her during an argument, and threatened to get her deported. It would appear that Miss Magana-Magana filed a Form I-360 VAWA petition with USCIS based on all of this. Unclear if she received a prima facie approval or if it was even actually approved, but Miss Magana-Magana filed a motion to reopen with the immigration court on that basis. After all, even if the I-360 is or was ultimately approved, and Miss Magana-Magana was recognized as someone who had suffered qualifying abuse or extreme cruelty, only an immigration court can legalize her status. Given the unexecuted removal order that came into existence when Miss Magana-Magana did not depart the United States with her voluntary departure grant all those years ago. But while the reopening statute is a bit more favorable, when it's VAWA-based, it still requires filing within 1 year. Miss Magana-Magana was well outside that from her removal order. She therefore argued that, quote, the severity of the abuse inflicted on her by Mr. Wakefield, as well as the domestic violence she was subjected to throughout her life, constituted extraordinary circumstances that should excuse her untimeliness, end quote. The BIA, in a very literal sense, was unmoved by the motion and denied. Now, it's true that the statute accepts the 1-year deadline where it's shown that there will be, quote, extraordinary circumstances or extreme hardship to the children to waive the time limitation, end quote. And after all, quote, the VAWA was a generous enactment intended to ameliorate the impact of harsh provisions of immigration law on abused women, end quote. And not just women either, by the way. But the BIA didn't see it, that is, sufficient grounds to reopen or extend the 1-year deadline to move to reopen. Here, the Ninth Circuit affirmed the BIA, but not before doing a whole lot of discussion on jurisdiction. And well, as this is a very long week, I'm going to streamline it. The Ninth Circuit held that it does indeed have jurisdiction to review the BIA's determination that a non-citizen has failed to establish extraordinary circumstances or extreme hardship such that a VAWA-based motion to reopen should be granted. And in so doing, the Ninth Circuit entered a circuit split, siding with the Fifth Circuit on this no less, a case from episode 107, again. To summarize many pages of analysis that discussed the Supreme Court's 4 recent decisions of Guerrero-Lasprilla, Patel, Wilkinson, and Boarfa. The Ninth Circuit saw the extraordinary circumstances or extreme hardship to children inquiry to be a mixed question of law and fact that therefore permits review. Under Wilkinson, quote, that is true even if the application of the legal standard requires close engagement with the facts, end quote. And it's not one of those crazy broad, standardless phrases, explained the Ninth Circuit. And as discussed last week, if I'm not mistaken. To put a pin on it, really helpful discussion of how to make these complicated jurisdictional arguments if your petition for review presents that issue, as so many of them do now. But on to the merits then. Well, the court affirmed the BIA, even while recognizing that the BIA seems to have mistakenly said that Ms. Magana-Magana needed to show exceptional circumstances rather than extraordinary ones, at least once, to obtain reopening. Clerical error at most, said the Ninth Circuit. Read in context, the Ninth Circuit believes that the BIA knew what it was doing. On to the merits of that then. Although reviewable, the standard of review is, quote, deferential, end quote. Thank you, Wilkinson dicta-esque language. For VAWA-based motions to reopen, more than simple abuse must be shown by that phrase, explained the Ninth Circuit. Terrible as domestic abuse is, every VAWA applicant trying to reopen their proceedings has abuse in their case, or extreme cruelty. So extraordinary circumstances to reopen a removal order where there are VAWA claims present must be more than simple domestic abuse or extreme cruelty, reasoned the Ninth Circuit. Nor did the court see a reasonable connection to the significant time lapse after the abuse before Ms. Magana-Magana filed her motion to reopen, which really is what the inquiry in this context is all about. And this, even though all courts recognize that Ms. Magana-Magana, quote, has suffered from serious mental illnesses, end quote, as a result of the abuse, it would appear. The BIA did enough, explained the Ninth Circuit. The court then refused to consider whether equitable tolling of the filing deadline was warranted, a close but distinct issue, because Ms. Magana-Magana hadn't made that argument before the BIA. Nor could the Ninth Circuit review the BIA's separate refusal to reopen sua sponte, as lots of precedent forecloses review except in the very narrow circumstance where the BIA relies on an improper, quote, legal premise, end quote, to refuse sua sponte reopening. All of it means that Ms. Magana-Magana and presumably at least some of her children remain ordered removed. And that is Magana-Magana v. Garland. Out of the Ninth Circuit we go, with Rodrigues v. Garland, published by the First Circuit on December 27, 2024. This case is about asylum. The petitioners here are a family from Brazil who were placed in removal proceedings to bring their asylum claims shortly after entering from Mexico. The father, Mr. Rodrigues, was the main applicant and claimed two reasons for his fear. One, drug traffickers seeking to collect a debt from his brother-in-law Daniel, who was involved in drug trafficking in Brazil. And two, his employer, fear of the Gardingo family. He was deemed credible as well. The drug trafficking stuff is essentially because his brother was involved with it and owes a lot of money to drug suppliers in Brazil, and the brother has been threatened. As to the Gardingo family, Mr. Rodrigues worked for this family, and they are powerful, both economically and politically, in his town. Mr. Rodrigues testified that the family essentially controls who becomes mayor of the town, and once even ordered the killing of a rival. Mr. Rodrigues doesn't support them politically and felt stifled while working for them. But he conceded that he was never harmed or threatened, and there's no evidence that the family is even aware of Mr. Rodrigues' political beliefs. So stated, an IJ denied asylum, and the BIA affirmed. The asylum and the withholding of removal challenges therefore traveled to the First Circuit, which affirmed the agency. In fact, Mr. Rodrigues never claimed to have suffered past persecution at all, at least before the First Circuit. But you can still get asylum, of course, without showing that you suffered past persecution. Past persecution just gets you a presumption that you have a well-founded fear of future persecution. And, quote, a well-founded fear of future persecution requires only a reasonable possibility that asylum applicants may be subjected to persecution upon return to their home country, which can be as low as a 10% chance, end quote. Unmet, though, said the court. A fear, yes, he has it. Even the government conceded this. But it wasn't objectively reasonable. Even if the drug stuff is on account of a viable particular social group like the Rodrigues family, the First Circuit didn't believe that it would probably happen. That is, what Mr. Rodrigues fears. He didn't have enough proof. Generalized country conditions about how drug dealers operate in Brazil isn't enough, explained the court. And in any event, those reports, quote, do not demonstrate a pattern wherein drug dealers retaliate against or single out the family members of those indebted to them, end quote. And although Mr. Rodrigues' credible testimony on this is evidence, he also, quote, himself admitted that he and his family have had no interaction with, let alone been harmed or threatened by, the Brazilian drug dealers who threatened Daniel, end quote. Restated, his fear was too speculative and not well-founded enough. Regarding the political opinion-based fear tethered to a fear of the Gardingo family, well, quote, it is not enough that Mr. Rodrigues holds certain political beliefs in opposition to the Gardingos, end quote. Rather, the would-be persecutors must know about it and want to target the person, quote, for that reason, end quote. Unmet in this case, as again there was no evidence that the Gardingo family knew about Mr. Rodrigues' beliefs, even if he was their former employee, and even if that family is known to make the lives of those that they don't like miserable, economically at least. The fact that the family may or may not have ordered the assassination of a political rival doesn't change this, given that 1, Mr. Rodrigues' uncorroborated testimony was the only evidence of this, and 2, the assassination was said to have occurred over 30 years ago against a highly visible political leader, which Mr. Rodrigues is not. Comparing this case to other asylum denials of the past, the First Circuit affirmed the agency's denial of asylum and withholding of removal. And that is Rodrigues v. Garland.
Are you struggling to find and hire new talent that you can trust? Does the idea of onboarding, training, and managing virtual staff overwhelm you? Staffy's got your back. Staffy provides top-quality virtual staffing for immigration law firms, complete with HR support to free up your time from the hassles of onboarding, managing, and continuously training your virtual staff. With an entire team of professionals, including psychologists and mindset, task, and performance coaches, Staffy ensures your virtual staff has all the tools needed to help your law firm grow and scale. Visit staffy.cc, that's stafi.cc, and schedule a consultation to claim $500 off your first month of service. Or, of course, click on the link in the show notes. You're probably hearing a lot of buzz about how law firms are starting to use artificial intelligence. And well, I recently had the opportunity to talk to the folks at Serenade about their case management system, e-immigration. They've been making software for immigration attorneys longer than anyone else. And they're doing some pretty cool stuff with AI. They have a suite of tools that they're calling AI Workmates. That sounds like it's got huge time-saving potential. One of their tools even lets you upload a PDF and instantly creates a client profile. There's another tool that can read content on the website and instantly summarize it, which is pretty helpful when referencing historical case rulings or, dare I say, country condition evidence. They've got some other tools too scheduled for release later this year. So if you're trying to wrap your head around how to use AI in your practice, I encourage you to have a chat with the folks at Serenade. Also, check out their blog at serenade.com/blog for their recent articles on AI in legal practices. Or, of course, click on the link in the show notes.
Hello again. Next is Chmukh Ruiz v. Garland, published by the 8th Circuit on December 24th, 2024. This case is about motions to reopen for non-LPR cancellation of removal. Mr. Chmukh Ruiz entered the United States without authorization in 2001. He has 2 U.S. citizen children, and when placed in removal proceedings, he applied for non-LPR cancellation, given that he had the 10 years in the United States and that he alleged that his removal would cause exceptional and extremely unusual hardship to his children. The thing is, though, that by the time of the merits hearing, the children were living with a foster parent and doing very well. And his two sons had only even recently learned that Mr. Chacon Ruiz was their father. So that's going to be a steep mountain to climb. Unsummited, reasoned the immigration judge. The BIA dismissed his appeal, and then denied a motion to reopen that was based on the fact that during the appeal, his then-partner had given birth to another child, who I'm sure Mr. Chacon Ruiz alleged he could now show the requisite hardship to. So the BIA denied that motion to reopen, but they did remand for the limited purpose of having the IJ issue a new voluntary departure period for Mr. Chacon Ruiz. Unsure why the BIA didn't just do that themselves if voluntary departure had been granted before, but there you go. So then, even though it was going back for voluntary departure period, Mr. Chacon Ruiz then petitioned for review the denial of cancellation or removal, which the Eighth Circuit held that it lacked jurisdiction to review. But still then, there's a remand for voluntary departure, and the IJ issued a new voluntary departure period. Mr. Chacon Ruiz appealed that to the BIA and then filed a second motion, a motion to remand, based on new evidence. He had a new wife now, and he cared for his stepchildren, all of them U.S. citizens. More potential qualifying relatives for non-LPR cancellation of removal. The BIA, however, dismissed the appeal, unsure what the basis was anyway, and denied the second motion to remand, deeming these new stepchildren, quote, insufficient to demonstrate the decision in this case would likely change, end quote. And now, Mr. Chacon Ruiz is back before the Eighth Circuit. The Eighth Circuit styled what it was reviewing a motion to reopen. After all, there was a final agency decision on non-LPR cancellation or removal when the BIA denied that second motion to remand. I suppose the Eighth Circuit reasoned? To succeed on a motion to reopen of any sort, among other things, the non-citizen must present new and previously unavailable material evidence that, according to the Eighth Circuit, quote, would likely change the result in the case, end quote. The Eighth Circuit saw no abuse of the BIA's discretion here in their denial of a motion to reopen. It's a short decision, as many Eighth Circuit ones are, and so there isn't much detail. Really, the court thinks that the BIA did enough in considering the new evidence about Mr. Chacon Ruiz's growing family, and the Eighth Circuit doesn't believe it was proper for them, that is the Eighth Circuit, to reweigh motion to reopen evidence. Now, before the BIA as well, Mr. Chacon Ruiz also tried to get the BIA to reconsider his eligibility for non-LPR cancellation of removal. The BIA declined to do so, and the Eighth Circuit said that that was okay, too. Recall, what Mr. Chacon Ruiz was trying to do was get reconsideration of that first and really only application for non-LPR cancellation of removal. But that was based on Mr. Chacon Ruiz's two first children, who, quote, were healthy and succeeding in school while living with their foster family, end quote. The Eighth Circuit saw nothing to reconsider, or that is to say again, that the BIA did enough. Meaning that Mr. Chacon Ruiz lost his case. And that is Chacon Ruiz v. Garland. Moving right along to Mateo v. Garland, published by the Seventh Circuit on December 24th, 2024. This case is about family-related asylum claims. Miss Mateo and her two minor children are asylum seekers from Guatemala. Miss Mateo started dating a man named Marco in 2014, and he is the father of her children. Miss Mateo was only 19 years old at the time. Marco's mother threatened to murder Miss Mateo a few months later for reasons unexplained. Then, when Miss Mateo became pregnant, she and Marco moved in with that mother. Sounds terrifying, and it got worse. Reading between the lines here, it seems like it was in part because Miss Mateo was Catholic and the mother wanted her to convert to Protestantism. How exceptionally 16th century. The mother harmed Miss Mateo every day, physically. When Miss Mateo became pregnant again, Marco left her for the United States, leaving Miss Mateo behind with his mother. The mother tried to make Miss Mateo miscarriage by repeatedly hitting her in that area. Horrific stuff. Miss Mateo couldn't take it anymore and moved in with her own mother. But then when the mother-in-law tried to lure the children away, she fled to the United States in 2018. An immigration judge found Miss Mateo credible, but denied her asylum application. The IJ didn't see a nexus to one of the many indigenous and female-type particular social groups proffered, but to me, reading this decision, I'm not sure why a religion claim wasn't asserted. Why tangle with particular social group viability when the mother-in-law is demanding that your client convert her religion? Additionally, though, reasoned the IJ, Ms. Mateo never reported any of this to police, so she hadn't established that the Guatemalan government was unable or unwilling to protect her. The BIA affirmed Convention Against Torture denial as well, given that Ms. Mateo didn't meaningfully challenge that denial. The Seventh Circuit affirmed the agency. Because, nexus and particular social group viability aside, Ms. Mateo apparently didn't challenge the unable or unwilling to protect finding, which is an independent reason to deny asylum and withholding of removal. So really that ends it, but the Seventh Circuit still discussed nexus for a bit in the alternative. It, like the BIA before it, saw this more as a, quote, personal animosity, end quote, from the mother-in-law, rather than because Miss Mateo was an unmarried indigenous woman or for related reasons. But man, that religion claim should have been brought. One of the 5 protected grounds, religion. The cases need not always be particular social groups. Also, a no-nexus finding will tank humanitarian asylum. Because while that rarely discussed form of asylum doesn't require a well-founded fear, it still does require all of the other asylum elements, including that the applicant was persecuted on one of the 5 protected grounds and that the government was the persecutor or unable or unwilling to control private actors. Summarily turning to cat protection, the Seventh Circuit held that it couldn't review the denial as the matter was unexhausted before the BIA. Gotta present your arguments to the BIA first in these petition for review cases, or the circuit is very likely unable and unwilling to review it. And here it is in a final footnote, quote, Ms. Mateo also attempts to revive her argument that the mother-in-law harmed her on account of her religion, but Ms. Mateo has waived this argument by not raising it before the BIA, end quote. Shucks. Unsure why the Seventh Circuit uses the word revive given how it described the claims before the IJ, but who knows? We don't always get the full picture in these decisions. All of it means, however, that Miss Mateo and her 2 children lost their case. And that is Mateo v. Garland. And so we conclude with Moctezuma Reyes v. Garland, published by the Sixth Circuit on December 23, 2024. This case is about non-LPR cancellation of removal. Mr. Moctezuma Reyes is from Mexico, and he came to the United States without authorization in 2005. Since that time, he's lived in Michigan with his wife and 3 of his 4 children. His daughter has DACA, and his 2 youngest are U.S. citizens, aged 14 and 7 years old. His wife is here without authorization as well. Mr. Moctezuma Reyes works at a fence factory. His daughter with DACA is a medical assistant, and together they earn about $50,000 a year to support the family in the United States. Mr. Moctezuma Reyes also sends back money to his oldest son, who is a student in Mexico. DHS initiated removal proceedings against Mr. Moctezuma Reyes for reasons unexplained and, apparently not having a fear of return, applied for the only thing that immigration allows him to apply for, non-LPR cancellation of removal under INA Section 240A-B. Congress, however, saw fit to make that difficult to get, and here it's going to come down to whether Mr. Moctezuma Reyes can show that his removal will result in exceptional and extremely unusual hardship to at least one of his minor U.S. citizen sons. An immigration judge in the BIA said that he could not meet that burden. And the Sixth Circuit affirmed. First, the Sixth Circuit answered a pretty important legal question for all of y'all practicing in the Sixth Circuit. What does the, quote, purely legal, end quote, definition of, quote, exceptional and extremely unusual hardship, end quote, mean? Before answering that question, the Sixth Circuit actually considered whether it should defer to the BIA's decisions defining that phrase, notwithstanding the Supreme Court's recent Loper-Bright decision. The reason, explained the Sixth Circuit, was that even after Loper-Bright, quote, the Supreme Court has instructed us that occasionally the best reading of a particular statute will reveal that Congress expressly and explicitly delegated discretion to the agency, end quote. But it's going to have to be really, really, really broad language and express delegation, reasoned the Sixth Circuit, or else it's just Chevron deference rebranded. Where this is even a possible reading of the statute, the Sixth Circuit explains that after Loper-Bright, a circuit court needs to, quote, first, independently determine the scope of Congress's delegation of authority to the agency, second, ensure the delegation doesn't violate the Constitution, and third, determine whether the agency's interpretation stays within the scope of the delegation, end quote. Interesting. Not so with the non-LPR cancellation of removal standard of exceptional and extremely unusual hardship to qualifying relatives. Broad language, yes, but no express delegation to the immigration agencies. It's not, for example, like language cited by the Supreme Court in the Clear Water Act, empowering the EPA to establish pollution limits that, in, quote, in its judgment, end quote, to protect, quote, public health, end quote. That's really broad and expressly narrowed delegation, and it's not present here. Rather, the hardship standard for non-LPR cancellation is a legal one that, if found, must result in a non-LPR cancellation grant, provided that the other elements required are shown too. More about this particular statute and Loper-Bright is discussed as well. So give this case a read if, in your petition for review, you're looking for arguments as to why and when a court must defer to the agency's reading of a statute, that is the BIA, even after Loper-Bright. But again, not the case here. So what's the phrase mean, Sixth Circuit? Well, beginning with dictionaries, quote, the word exceptional means rare or deviating from the norm, end quote. The word unusual has a similar meaning. Hardship becomes rare then, quote, either in terms of the degree or the type of hardship, end quote. It's hardship, quote, significantly different, end quote, than what qualifying relatives normally suffer when their family member is removed, reasoned the Sixth Circuit. Really explained the court, it came to the same conclusion as did the BIA way back when in 2001 in matter of Monreal and Guianaga. Put another way, quote, differences in degree can be differences in kind, end quote. You can still make a sufficient hardship showing if the expected hardships, like financial difficulties or emotional harms, are severe enough. Or, of course, you can point to truly unique hardships. Those are the two ways. Unmet here. The two children appear healthy, and if they take a financial hit, well, our system expects that, reasoned the court. Plus, Mr. Montezuma-Reyes' daughter helps support the family too, remember? Hope that DACA sticks around. Undiscussed. Plus, Mr. Montezuma-Reyes didn't show that he'll be unable to work in Mexico, even if it, quote, may prove difficult, end quote. Nor do the children have, quote, compelling special needs in school, end quote. Might win your case, though, if you can show that your qualifying relatives have that. Also, this all has me wondering what mere, quote, extreme hardship, end quote, means, as used in other statutes. For another day and another case. Congress passed a really harsh law when it got rid of suspension of deportation and replaced it with non-LPR cancellation of removal. I commend the Sixth Circuit for its final paragraph, quote, in laying out why Mr. Montezuma-Reyes can't stay, we've omitted much of what makes him the man he is. A devout Catholic, a loving father as well as husband, and a godfather to 6 children. As the immigration judge described Mr. Montezuma-Reyes when explaining the decision to deny his application, he's a good person, a good father, a good husband. But just like that judge, we must uphold the law, end quote. And the law can change if we as a country believe that it should and urge our representatives to prioritize it. Mr. Montezuma-Reyes, though, remains ordered removed and very well may be removed soon. Judge Stranch concurred and believes that deference is warranted, notwithstanding Loper-Bright, if for no other reason than stare decisis. Tricky stuff, admin law and appellate law. Which brings me to this. In this case, like the Ninth Circuit before it a few weeks ago, the Sixth Circuit notes that the Supreme Court said in Loper-Bright that the prior decisions that had relied on Chevron deference remain binding because Loper-Bright simply changed the, quote, interpretive methodology, end quote. That is, stare decisis remains of the old decisions. As I've mentioned before, I read Loper-Bright as saying that the Supreme Court's prior precedent relying on Chevron, remain good law, but not necessarily that the same rule applies to the circuits. After all, how could it? The Chief Justice essentially said in Loper-Bright that Chevron deference was a constitutional abomination and that federal courts must define statutory phrases. But as this is now the second court to say otherwise, that is, that their prior precedent remains good law, notwithstanding the vacature of Chevron, I'm likely wrong. Gonna keep arguing it, though. It just doesn't make sense to me. Regardless, the analysis in this Sixth Circuit decision is kind of how a court can walk the line of interpreting statutory language without running up against stare decisis and its prior precedent. To me, it means that circuits can indeed change the definition of, say, a CIMT, so long as they don't directly contradict a prior decision, like, say, a decision holding that a specific crime is or is not a CIMT. To me, at least. And if that's the case, Loper-Bright, of course, remains very powerful. Read the decision and let me know, circuit practitioners. And that is Moctezuma Reyes v. Garland.
So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview, that's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to, from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.